Hi, bankruptcy attorney Brian Barboza here. Today I'm going to discuss whether a bankruptcy can stop a lawsuit that's filed against you. Before we get started, if you want to talk about bankruptcy, you want to explore your bankruptcy options, please don't hesitate to call my office, or you can go to my website, barbozalaw.com, and you can book an appointment to speak with me directly right through my website. So, will a bankruptcy stop a lawsuit? So often I have people that come to my office and they bring with them a summons and a complaint, which means that they have been sued. They usually have been sued by a credit card company, a debt collector, or or a medical bill or something of that nature. And so now they're somewhat frantic because they have 30 days to respond to this lawsuit and they don't know what to do. And so whether or not bankruptcy is a good alternative depends on their situation, but bankruptcy will stop the lawsuit. The way that works is when you file your bankruptcy case with the United States Bankruptcy Court, an injunction goes into place by operation of law. We call this the automatic stay. So automatically, when the bankruptcy is filed, debt collectors and creditors are enjoined, they're legally stopped from taking any action against you during your bankruptcy case. So this means continuing with a lawsuit. This means garnishing wages, levying bank accounts. So the bankruptcy will stop the progression or the continuation of that lawsuit. It's going to be a best practice, however, when you file bankruptcy to go down to the state court and file, at least in California, what's called a notice of stay. And so that just puts the Superior Court of California on notice that there is now a bankruptcy open and that there is a federal injunction that will no longer allow that lawsuit to continue, at least while the bankruptcy is open. So long as you successfully complete your bankruptcy case, Chapter 7 or 13, if the underlying debt for the lawsuit, let's say it's a credit card debt or a medical bill, those debts go away and then the lawsuit goes away. So if the debt was then discharged in the bankruptcy case, then the creditor who sued you has an obligation to dismiss that lawsuit in state court. So the short answer is yes, bankruptcy will stop a lawsuit. If the bankruptcy is successful, the lawsuit goes away. And that is only if, however, the underlying debt that you're being sued for is the type of debt that you can actually get rid of in a bankruptcy case. So, for instance, if you're being sued for, let's say, student loans, and those student loans were not discharged in your bankruptcy case, then in that instance, the creditor could resume the lawsuit after the bankruptcy is open. But assuming we're talking about things like credit cards, unpaid medical bills, maybe a breach of a prior lease, any other type of debt you can get rid of bankruptcy, maybe an auto repossession, the bankruptcy will stop the lawsuit from continuing, and once the bankruptcy is over, the lawsuit will also end. So that's it. I hope this offers some peace of mind to you if you're dealing with this problem. If you want to talk more about bankruptcy, please, again, give my office a call, law office of Brian Barboza, or go to my website, barbozalaw.com, and book an appointment directly with me. Thank you so much for watching this video. I really appreciate your time, and have a good rest of your day. Bye.